Welcome to today's program titled COVID-19-Related Consumer Class Action Developments and Trends in California. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Robert Milligan. Robert, you may begin.
Thank you, and thank you to the audience for joining us for today's webinar. As you see on the screen, we have a legal disclaimer. This is not legal advice, and although we hope to have a very fulsome educational discussion, if you have specific questions, you're urged to consult a lawyer concerning your own situation and any specific legal questions that you may have. We have an ambitious agenda for today's discussion. What we tried to identify for the audience is some of the consumer class action issues that businesses conducting business in California face in light of this COVID-19, something that's entirely unprecedented. And we tried to tease out what we're seeing as far as the main issues, the main legal claims and defenses, potential ways to address the issue, and strategies on a going forward basis to address this new world that we're living in. California is obviously a very favorable jurisdiction for plaintiffs who attempt to bring class actions, apart from the statutory environment that allows for private claims. And it's a very broad unfair competition statute. It also can be a very favorable jurisdiction with respect to the courts as far as approving class actions, certifying classes. And so we expect, and then obviously with respect to what's going on with COVID and the number of folks that have been impacted in California, the sheer size of California as a business market, we've seen a tremendous amount of class actions to date, and we expect to see more. So I think sort of the takeaway that from a big picture, depending upon your various business and your business model, is that you can come across with some tips or practices that you might be able to employ with your consumers on a going forward basis to protect against potential class actions. As far as our agenda, we tried to isolate 6 main areas where we're seeing a lot of action, and we've tapped our firm's resident experts in California on these issues for today's discussion. That's not to say that this list is finite, and this particular list, each of these topics could probably have their own webinar dedicated to the topic. Obviously, there's other issues that are coming up as far as false advertising, Telephone Communication Protection Act claims for text messaging, and then obviously privacy, premises liability as it relates to returning to work and some of the privacy issues that are going to come out of that. But we tried to identify 6 main areas. I'm going to cover the tuition and fee refund actions that we're seeing, and then we're going to switch to Darren Dummett, who's going to cover some of the refund actions that we're seeing with sports teams, conference, festivals, and ticket brokers. He's also going to cover some of the class actions that we've been seeing in the membership and subscription refund sector as it relates to gyms, theme parks, ski mountains, and semi-private clubs. John Bronstein is going to get into some of the price gouging claims that we've been seeing on high-impact products and services during COVID-19. And then finally, Josh Salinas and myself are going to tag team on some of the privacy actions that we're seeing, as well as some auto renewal and deceptive pricing actions that we've seen come up. Briefly, just tell you a little bit about our panel. John Bronstein is an experienced partner in our San Francisco office. He has a tremendous amount of experience in commercial litigation and class actions, and he's going to be covering our price gouging topic. Darren Dummett is a senior counsel and is a former in-house counsel and has a tremendous amount of experience in the sports and the sports sector. And he's going to be covering, as we indicated, the membership class actions and the sports refund class action issue. Myself, I'm a partner in our Century City office. I'm joined by Darren and Josh. We're resident in our Century City office, and my practice area includes consumer class actions, handling over 50 consumer class actions over my career. And then Josh Salinas. Josh is one of our senior associates, one of our best and brightest, and covers a lot of consumer class action actions themselves, as well as some of the advice and counsel behind the scenes. And he's going to be covering our privacy and automatic renewal deceptive advertising topic. With that, let's jump into the tuition and refund actions. And I think when you look at these 6 distinct topics, there's things that you can learn from each of the topics just about some of the claims that are being brought and some of the defenses that are being brought in those particular actions. And there is actually some overlap because they're dealing with, basic general attacks to the way that companies' business model works, and then ways that they're trying to respond to these attacks on the various business models. And so, as we look at this in sort of a California-centric viewpoint, but it does have application on sort of a nationwide basis, generally we're seeing a tremendous amount of putative class actions being filed across the nation against schools, higher education institutions, making claims on behalf of students seeking reimbursement for tuition, fees, room and board. There's also some miscellaneous claims related to that. There's been over 10 suits filed in California to date against higher education institutions, and we've seen over 100 suits nationwide. Some of the top universities in the nation have been targeted. It depends, but in general, what we're seeing is a lot of out-of-state counsel filing the action and using a local counsel as either a post box or that may have some substantive experience with the particular court that they're being filed in. By and large, and obviously there's exceptions, but these cases have been being filed in federal court, and it's the entity themselves are seeing multiple actions being filed. So you'll see several copycat actions filed by different plaintiffs, but against the same institution. And this practice you can probably see in some of our other 5 topics as well, as far as there's going to be multiple actions filed involving the same consumer, or in this case, students. What's interesting about the vast majority of the cases that are being filed is that although the plaintiff's counsel is bringing an action for breach of contract, among other claims, they are not actually attaching the contract. And that can often be a very interesting tell, because it might be because there is no underlying contract as far as a written agreement, or it could be a series of various agreements and policies and whatnot, and so that may be the reason why they're not attaching the agreement. In other instances, it might be that they're not bringing the agreement because there may be a arbitration provision or a class action waiver in that type of agreement. So in many of these cases, I think what you'll see is some attacks, some Twombly type attacks as far as the lack of certainty that's being provided about with respect to the contract itself, and why it's not being, asking the question as far as why it's not being attached to the underlying complaint. And, as far as the remedy that they're seeking is, in general, they're seeking partial refunds on tuitions and campus fees, saying that they're not getting the caliber of education that they were promised. So instead of the live instruction and having the access to the campus and the various facilities, whether it's the gym, the library, other aspects of the campus experience, being able to participate in student government or clubs or intramurals, whatnot, they're saying that being given the online environment for learning is not the same, and that they're asking for a partial refund on tuition as well as on campus fees. In general, many colleges are rejecting the idea that refunds, as it relates to tuition at least, are in order because students are learning from the same professors who teach on campus, and students are still earning credits towards their degrees. In general, and it's run the gamut, but by and large, you're not seeing a lot of tort claims being brought in these particular lawsuits against higher education institutions. And with that, I should note that apart from higher education institutions, this service of providing educational instruction, you're going to see a similar type playbook. There's obviously things that are unique to higher education, but if you're an educational provider, whether it's higher educational or athletic instruction, other types of services that are being provided and that have had to switch to a online environment, you're probably going to see similar type claims. But the claims there that we're seeing are breach of contract, unjust enrichment, conversion. On the California cases, we're seeing unfair business practices under Business and Profession Code 17200. And one of the big questions is, are we going to see tort claims? And at this point, in general, they've been avoiding asserting the tort claims. I think there's concerns with respect to potential defenses on sovereign immunity that may be brought by public institutions, as well as probably may not be a factual basis to assert a claim for fraud. Most educational institutions are dealing with the pandemic and are doing their best, and are offering, maybe refunds as it relates to student fees, as it relates to room and board, and prorating the room and board. And so to say that there's a basis for a fraud claim or another tort-type claim is a stretch, even for the plaintiff's bar. But I think you probably will see some tort claims as this litigation proceeds. As the slide that you see in front of you, it's a bit of a daunting slide, but it kind of lays out for you, some of the thought process from the plaintiffs and the plaintiffs' class action bar as how they're looking at these type of suits. These particular quotes are coming from some of the major newspapers that have been covering the lawsuits. And you could see that there's a real focus in the plaintiff's claim that there's a diminution in value as far as online instruction compared to what is alleged to be the benefit of the bargain, which was live instruction. And there's also talk of the experience of living on campus, being able to use campus amenities and services, eating in the cafeteria. And trying to tie that to a general sort of contract claim. And like I indicated, that many institutions have provided refunds for room and board and other student fees related to being able to go to the library, use particular facilities like the gym. Oftentimes it depends upon how the individual institution, what their contract looks like, how they've itemized the various fees. But one sticking point is obviously the tuition. And at this point, many schools have not been willing to prorate the tuition. A statement from the Cal State system, which got hit with one of these class actions, is that they believe that they have continued to provide instruction online, and they have continued to provide services to the to the students, such as counseling, faculty hours, telemedical care, and so the allegations made in the lawsuit that all services had been sort of cut off or had been cut off. They objected to as a misstatement of the facts as far as some of the allegations made in that particular lawsuit. But as indicated, they are refunding some of the fees. The rubber really hits the road with respect to the issue on tuition. As far as expected defenses and defense strategies, when you look at the underlying claims, I think there's going to be a lot of pleading challenges that there hasn't been a breach. It may get into summary judgment type issues, but when you actually look and unpack the contract terms, what type of discretion did the education provider have in providing services? And if tuition, it doesn't specifically say that it has to be, in-person instruction, it's going to be a more difficult test for it's going to be a more difficult standard for the plaintiff's bar to reach if the education provider has more discretion. And there's actually some pretty good case law coming out of California where the courts have been very reluctant to make academic judgments as far as what vehicle to provide education instruction is better, and sort of viewing these as educational malpractice cases, and that being a issue that the courts are deferring to the educational providers about how to best provide the services that the students pay tuition for. There's going to be defenses such as substantial performance. Arguments will be made, based upon the contract and whether they have, the specific language with respect to force majeure and related contract defenses such as impossibility. California being one of those jurisdictions that provides defendants more latitude as far as how they interpret force majeure clauses. You're going to see defenses regarding limitation of remedies that are provided for in the contract. You'll also see, obviously, offset for proration of refunds that have already been made for room and board. Obviously, there's going to be a lot of issues with respect to a class challenge and basically saying, how can you compare somebody that's taking biology classes to somebody that's taking history classes, and they may not be at the same impacted as far as how the online instruction impacts them. A biology student may need to be in the lab, and they may have a more colorable argument. The other thing being arbitration provisions and class action waivers being in arbitration provision. I mentioned that some of the public institutions may try to invoke sovereign immunity to try to withstand some of these suits. One thing is, whether or not the education institutions are going to be willing to do an early class settlement, and whether that class settlement would be some sort of coupon or voucher for future fees. So when we look at sort of how companies and higher education institutions can manage the risk on a going forward basis, they need to take a look at their agreements. What do their agreements look like? Do they feel like they're in a good position? Do they have the class action waivers, arbitration provisions? Have they limited remedies? Do they have discretion on how do they define the educational experience and what it consists of tuition? It's an evaluation of financial circumstances as far as do they even have the ability to make the refunds. In many instances, they're not. And it's also a consideration of whether they should be adding some language to their contracts on a going forward basis, to address this, as we get into the fall, the fall season, and whether they need to shore up some of their contracts. With that, I'd like to pivot and turn it over to Darren Dummett, who's going to cover our next two topics. The first topic being refund actions against sports teams, conferences, festivals, and ticket brokers. Darren, it's all yours.
Appreciate it, Robert. And we sort of go from one of the most essential aspects of our society in education to what some people consider a luxury in sports and concerts and the like. However, we've seen that sports and live entertainment has sort of wagged the dog in terms of the collective consciousness of the pandemic. We all saw this after Rudy Gobert went to the hospital and after the NBA canceled its season. Everyone took it pretty seriously right after that. And then we've seen it in the litigation context, even though teams are grappling with whether or not their events and concerts, whether or not their events are just postponed or whether or not they're canceled, and they're grappling with what their events will look like in the future. And so it's very instructive about what we've seen in this area, what we will see in this area, and how that will extend to the other areas of the law. But we've seen a lot of these organizations respond in a variety of different ways. Some have paused and just tried to figure out what their sport will look like, what their event will look like in the future, and has asked their consumers to wait while they figure this out. Others have been more proactive and have offered, of course, future events and future credits, and then some have not had that option and have gone to bankruptcy. But sort of in all three instances, we've seen class actions already be filed, and very often before decisions about what the future events will even look like. And so there are a lot of different considerations that these companies will need to look at as they alter or enforce their refund policies. And a lot of the stuff these companies already know, but the consumer don't know. The funds that are paid in advance, they're often not just put in a lockbox, but they're used right away for stadium improvements, for non-refundable deposits and staff. And so for that reason, these organizations may not have the ability to provide full refunds, at least not all at once, at least not to everybody. Under normal circumstances, though, a lot of organizations value customer connectivity above all else. So even though they may have the ability to provide a refund, they don't want to, because when you have a credit for a future event, you are connected to that team somehow. And so that's what organizations and teams want to strive for, but they also want to strive for brand loyalty. And those teams that have been around and those organizations that have been around for a long time, they have that brand loyalty, and they can afford to be a little more stringent in their policies. But the newer teams and the newer sports and the newer events, they may not have that, so they may want to foster brand loyalty by providing full refunds. And so you've got the teams, they like to keep some future credit. You've got the festivals, they aren't used to canceling outright, so they like to try to provide some future credit if it's postponed. And then you have the ticket brokers who often act as middlemen, and they refund for anything that's canceled, but they will postpone, usually. They will keep the money until the event takes place in the future. This obviously can vary when you have contracts with ticket brokers that are exclusive to one league, when you have preferred ticket brokers for some teams, when you have third-party ticket brokers, etc., and when the teams actually sell their tickets on their own platforms. We'll get into that some more. But as we move along, we saw one of the first class actions, which was filed in mid-April against Major League Baseball, against all of their teams, and against each of their major ticket brokers. Just like Robert went into, we saw the breach of contract, the unjust enrichment, the violation of California's business practices and consumer protection law, despite the fact that the named plaintiffs bought tickets for Yankee games and Mets games. Robert touched on some of the reasons why California is a hotbed, and we'll be talking about that more. But there was also a civil conspiracy claim as between the leagues, the teams, and the ticket brokers, saying that each party knew or should have known that the games were canceled right away. Therefore, them holding the payments is essentially a interest-free loan, even though they know that these games won't be played or they won't be played with fans. So is the argument, at least. Major League Baseball, while they were trying to figure out what was to happen, told their teams not to issue refunds right away, and predictably there was a lawsuit filed. But even after Major League Baseball lifted that moratorium and said teams can act on their own, the plaintiff's firm that brought that case said this will not deter them from continuing to go forward with the lawsuit until every person from every team has gotten their full refund, and likely until plaintiffs' attorneys get their fees, of course. And so that tells you that even when you are trying to be measured, the delay will be seized upon by plaintiffs' counsels, and that's something that should be looked at. As the leagues going forward who who have either paused or who will start their season soon. So you have the NBA, who will be looking at potentially a third site where they will, or a neutral site for all teams where there will be no fans. Obviously, those games would be, in one sense, canceled, and they'd be looking at refunds for that. They don't know when that will be reopened. And for the NFL, they may be going forward in their home stadiums, and yet their home stadiums may be to 20 to 30% capacity. The conversations are even trickier around college for a variety of reasons, but we're going to have the same issues come up and the same speed with which they will likely file suits. When we look at leagues that may not be on as firm ground, we look at the upstart football league this past spring. As a result of the pandemic, they were forced to cancel their season. When they did that, they were a younger league, so they were prone to giving full refunds, and they gave an option for a credit for next year or a refund. However, the nature of the pandemic forced them to go into bankruptcy. And before filing for bankruptcy, they changed their refund policy to provide a full refund to everyone. Well, they couldn't provide it right away, but they provided the right, and they did that. A lot of observers have remarked for business reasons, perhaps outside of the football league, so as not to upset the other fans of the other sports that may be involved. And so they went to the bankruptcy court. They asked for the full refund to be provided to all of the season ticket holders right away, and the bankruptcy judge has so far not acted on that request, that it's premature, and people are still waiting. So this highlights the other business considerations that will be at play even through bankruptcy. Then we're looking very similarly at concerts and festivals, and the financial realities come into play there. There's non-refundable deposits, there's building materials, there's staff that complicate the use of funds. So you've got three different approaches. You've got the Coachellas of the world that are backed by larger companies that have offered full refunds until a time in the summer. You have the South by Southwest. They claim that they were hit really hard financially. They were unable to provide a refund, but they provided credit for admission to one of the next three annual festivals, plus other future discounts. And then there's Lightning in a Bottle Festival. They not only said that they couldn't provide a refund, but there was no promise that they could be around for next year. And they flat out told their consumers they may be going in to bankruptcy. And quite predictably, we've seen class action litigation, not against Coachella as of yet, but against the other two. One of them was filed in California, of course, and South by Southwest filed in Texas, which also highlights the venue and choice of law considerations. But the plaintiff's attorney in Lightning in a Bottle has made no secret of the fact that they believe that the organizers are simply trying to reorganize, run away from their obligations, pocket the money, and then run the festival under a different name. Of course, that's plaintiff's attorney speak, and those are allegations. But those are the allegations that are already being made against companies that are obviously hit with these difficult considerations. So. With these difficult times, class action litigation seems inevitable at some point. So we look at how we defend these. You first got to look at the terms and conditions, like Robert talked about, class action waivers, arbitration agreements. In California in particular, there's been some recent case activity regarding the unwaivable public right and the waivable private right. There was even a case in the news earlier this week regarding a arbitration agreement not being enforced because the language was not clear and conspicuous enough. And so we can talk about that later, but what can these companies do? Well, first you can point to a variety of platforms that consumers can get the tickets from, whether it's the team site, whether it's the brokers, whether it is the league site, however you want to slice and dice it. It is hard for plaintiffs to argue that this would be a a unconscionable contract of adhesion when there are multiple points at which they can get them. Going forward, as we look to the refund policy, these companies will be wise to offer a variety of different ticketing options that not only makes the consumer feel like they're more engaged, like they have options, they're not getting it crammed down their throat, but also it helps defeat class certification claims and the like. We talked about the clear and conspicuous language in the terms and conditions as well. If the terms and conditions cannot be altered at this time and are silent as to these issues, we talk about force majeure, whether or not there's any language in that contract, and then also the common law principles of impossibility, impracticability, and frustration of purpose. Here, the size of the market and the television deals or the other sponsorship deals in the concert space, those will be large factors. It will be harder for a National Football League team with a large television contract to make the argument, make the same argument that the XFL made with a television contract where essentially they paid for the rights to be broadcasted. So these are all very important, and once again, choice of law is very important. California has a broader applicability in force majeure than other states, and that can come into play. We don't know how it will in the future, though. Looking ahead, what we started off with, teams and concerts and conferences may need to revisit the traditional uses of their cash flow. Meaning they may not want to allocate it. They may want to keep a larger slice of it just in case there is what is now foreseeable pandemic that shuts down their entire activities for a period of time. They would be wise to update their terms and conditions to include flexible refund policies in addition to updated force majeure language. And then we just talked about it. Not only should multiple alternatives be offered, but teams and organizations should track customer utilization better and maybe have new technologies that will help track that, help deal with damages claims from plaintiffs and class certification issues. We'll talk about that briefly in the next section as well. And then going ahead, like we talked about, season ticket holders who may not have the same access to tickets with social distancing restrictions or priority passes at concerts or conferences, that should be the next wave of litigation that we're going to be seeing. And so as we move on to the membership aspects, membership and subscriptions, very similar sort of arguments. However, here the advance payments were made for annual memberships or subscriptions, or there were recurring monthly payments that are automatically withdrawn. You see this with gyms, with workspaces, with theme parks, ski mountains, and all of the social clubs. And they respond a variety of ways. They've been given full refunds, partial refunds. Some have froze payments, some have issued future credits, and some have done nothing and continued to withdraw the amounts. And the plaintiff's lawyers have continued to act. So just quickly going through some of these, some of the largest national chains of gyms in the country, they did not suspend payments for the first few weeks of the pandemic. They eventually did, but a couple days after doing that, class actions were filed. Regardless of that action, they were filed in California and New York, and on the same grounds. And sort of going forward, as we'll talk about, not only will we see some liability for the period of inaction or a potential liability, I should say, but there will be the risk of litigation when these gyms reopen and there is a diminishment in value when there are not as many people in the spin class, or when there are individualized health risks by people saying that they either are at an extreme high risk or they don't feel comfortable being in these spaces anymore. So companies will need to look about how to deal with those complaints and those situations. The same situations are present with shared workspaces that have continued in some cases to charge full membership fees despite the offices being closed, and in some reported cases despite those companies receiving discounts on the rent that they pay to landlords, which would be a tricky deal public relations wise as well, and on the unjust enrichment side. But thus far, we have not seen any class actions, potentially because of the presence of arbitration agreements and class action waivers. In fact, one of the most notable companies, there's a plaintiff's attorney that's trying to represent a class that has made a letter to the company public requesting that they waive the arbitration provisions or allowed the class to proceed as a class. So that highlights the importance of that. We've seen this in theme parks as well. Those with the means have offered a lot of different choices, including prorated refunds and retroactive refunds, while others have just been silent and continued to withdraw membership fees. And just as we saw in some of the last examples, multiple suits have been filed against the theme parks that have not provided any such refund. So these companies both have the same goodwill, but the financial realities may dictate class action exposure. The same thing happens with ski mountains. As we all know, they've been largely consolidated in the U.S. Over the past few years, and you have one major player who's offered a discount on a sliding scale that's applied to the purchase of next year's passes, while the others just offered a discount on the early renewal fees for next year's passes. In both instances, the refund option is contingent on paying more money to enter into a new contract, and in both instances, class action litigation has already been brought. We're going to be seeing this more in the area of private clubs. Some of the semi-private clubs have already been hit when they did not freeze the automatic deductions. In fact, these owners of these private clubs, which also contract with other third parties to provide access to other restaurants, they will bring. There's also some potential for those third parties to be involved in some litigation. So that is a mess that needs to be dealt with quickly. Lastly, how do we defend these? You can try to provide a full refund or try to do nothing and hope that the consumer is silent, but that won't always work. So you look at the terms and conditions, and hopefully you've got something in there that contemplates some form of suspension or rollover. If not, the courts may view that as a change terms. It will be harder, though not impossible. As we talked about, we'd like to try to resolve customer issues on a case-by-case basis. Want to try to offer multiple alternatives and track customer utilization with additional technology. The customer usage data can identify the differences, can reduce the damages as you track who availed themselves of the benefits, and can also be used for a variety of other business reasons. Looking ahead, as we've been talking about, they're going to encounter the same problems as they reopen, and companies must decide how to act, how fast to act, or else face the risk of litigation. So they would be wise to include a lot of the same issues that we talked about in the last section. I ran a little over, but I'm going to throw it over to John Bronstein, who is going to talk about price gouging that has come up recently.
Terrific. Thank you, Darren. All right, price gouging, actions involving high-impact products and services. Price gouging is a hot topic right now, and we will talk about what it is and why it's a particularly hot topic. We'll look broadly over the next few minutes how it's treated nationally and then we're going to really focus in and hone in on California and some of the early class actions that we're seeing in the price gouging space. So first up, price gouging. Conceptually, what is it? Price gouging occurs when during abnormal market conditions, the seller increases the prices of goods, services, or commodities to a level much higher than is considered reasonable or fair, right? So, unreasonable or unfair, right? Unconscionable or exorbitant pricing, right? Often occurs after demand spike or supply disruption during a public emergency. The most common examples, right, involve excessive price increases for basic necessities after natural disasters, right? Think if there's a windstorm or an earthquake, power goes out, and there's a spike in demand for flashlights and light bulbs, something along those lines. In many jurisdictions, including California, price gouging during a declared state of public emergency is a crime. It's governed by the California Penal Code, and we will get to that later on. Whether criminal or not, price gouging is generally discouraged and may be considered exploitive and unethical. Think of it as a social, societal social contract, something you would teach your kids. This is bad. Don't take advantage of other people. This is profiteering. Just don't do it. Conceptually, price gouging is usually a short-term, localized and restricted event. It's usually of short duration, following a natural disaster or something along those lines, and it's limited to traditional essentials such as food, clothing, shelter, medicine, and other equipment. But as we shall see in the next slide, COVID-19 is not your traditional national disaster or natural disaster, and it's not your traditional public emergency. COVID-19 is an unprecedented historic event, and it presents uniquely different issues than a traditional national disaster. And as such, right, you see an unprecedented opportunity for price gouging. Well, what makes COVID-19 so unique? Certainly, it's an expansive geographic scope, right? This is literally a worldwide phenomenon. You have a long extended period of emergency with no known definitive end date. As we'll see later, declarations of emergency usually run 30 days or less, or maybe a week or 2 weeks. But we're now in our third month and still going. And as we'll see later, California's declared state of emergency, at least for price gouging purposes, is going to run at least through September of 2020. Another unique thing about COVID-19 is we're seeing a run on the bank, so to speak, both in traditional items, but also non-traditional items. So, for example, right, traditional necessities, or at least things that we would expect to be necessities in a healthcare pandemic such as this one, personal protective equipment, disinfectants, hand sanitizers, etc. But we are also seeing a run and price gouging on products, right, that really seem, at least intuitively, to be independent of the healthcare crisis, right? So you're seeing a run on toilet paper, eggs, hair dye. You may have read an article or two. There seemed to be a run on that. My own experience, exercise equipment. If anyone's tried to get a puppy, there seems to be a run on puppies. So, just a run on different types of products and goods and services in the market. Some that you would expect and some that you wouldn't. All right. Also there's new items in the marketplace, right, that didn't really exist before, such as, COVID-19 testing kits. And just as an issue, how do you price those? How do we gauge whether the price is right or whether, there's exorbitant pricing for new items in the market? The end takeaway from this slide really is that COVID-19 presents a tremendous, unprecedented opportunity for fraud, for price gouging. Wherever you find money and you find opportunity, you're going to see financial wrongs and financial crimes, essentially such as price gouging. What are the sources of regulation for price gouging? There's no federal law against price gouging, but there are multiple bills pending. President Trump did give an executive order that focused on preventing the hoarding of health and medical resources to respond to the spread of COVID-19. You can see that language here on the slide. Most of the regulation is done at the state and local level. More than 35 states, including California, currently have price gouging statutes. And as I said, we'll focus principally on California here in a minute. But do also know that there are state and local executive orders that usually correspond and supplement with, the state law in each jurisdiction. All right, sources of potential legal claims. This is enforcement, right? This can be price gouging issues can be enforced both by the public sector and the private sector. Certainly for purposes today, I really want you to focus on the top two bullets there that are in blue, customer and consumer lawsuits and class actions, as well as employee whistleblower and retaliation suits. State Attorney General, Federal Trade Commission, they can also enforce this, but as consistent with the theme today, really want to focus on consumer class actions, consumer theories of liability. All right, civil actions, civil damages, criminal actions are going to have criminal damages fines. And in the state of California, you can be imprisoned. Okay, we're going to spend the next few minutes really digging into California. Price gouging. So on March 4th, Governor Newsom declared a state of emergency in response to the COVID-19 crisis. It's Executive Order N4420, and it makes it unlawful to increase the price of food items, consumer goods, or medical and emergency supplies by more than 10% of what a seller charged for that item as of February 4th, 2020. The key metric here is 10%. I think I missed a slide earlier, but that's okay. Different jurisdictions have different ways they go about this. Some use those undefined terms, right? Excessive or exorbitant or unfair or unreasonable. And then you have to work through and figure out, exactly what is the threshold, right? Another way of doing it is what California's done, right? Which is to pick a number. And California says, look, if you raise the price of your good or service for an essential necessity, more than 10% during the period of emergency, and we're going to measure, the price that you're selling it now, relative to what you were selling it for on February 4th, 2020. If you're up more than 10%, that can be considered price gouging. Another way, and only a couple jurisdictions do this, they just say no cap, no price raising. During a pandemic, you can't raise your price at all. That seems a little harsh. There may be reasons to raise prices, but in any event, California adopts this 10% rule. There are, of course, exceptions to that, and the main three, and there really are three. One of which is if your costs go up, right? Your costs to get, receive, to make, or deliver the product, go up. You're a retailer. If the manufacturer's price goes up and then the wholesaler's price goes up, the price is going to go up when it gets to you. You're not expected to take a loss. If your cost to deliver a good or service goes up, you can raise your price accordingly. The second major exception is sales pricing. So, for example, if you had a product that you put on sale at a discount, then and you're just returning it now to the original price, right? That doesn't run you afoul of price gouging statutes and price gouging law. So you sell T-shirts. Normally they're $20. You drop the price down to 15 for a holiday sale, and now you raise the price back to 20. Even though that's more than a 10% increase, you're not going to run afoul of price gouging law in that circumstance, right? The last major exception, which isn't here, but it's worth talking about, is the government. If you're selling goods or services to the government, and the government consents, acquiesces, agrees, to buy it from you on those terms, well, then, you don't run afoul of price gouging law, and no one's coming after you because the government says it's okay. Just stepping back, what I'd really like everyone to think about is, are you raising prices or just going about your business in a normal way, or are you out there trying to take advantage of the current dynamic in a way that's, predatory or profiteering? If you're doing the former, right, you're probably okay, but obviously you need to be mindful of the 10% rule. But if you've got predatory intent and you're raising your prices 10%, that's going to be a problem. All right. One other thing to talk about on this slide is just the idea that items that didn't exist, right, at the time. So we can't go back to February 4th to look at the price of your item if it didn't exist then. So here's the rule for that, right? If a seller produces the item, a new item in the marketplace, they can't sell it for a price that's greater than 50% of the cost to produce. Or then further up the distribution chain or the sales chain, if the seller didn't offer the item for sale on February 4th, you can't sell the item at a price more than 50% greater of what you paid for it. All right, Penal Code Section 396. During a state of emergency, right, here's the big California statute, and I've highlighted, I think, the key points in bold. During a state of emergency, including disease, right, COVID-19, merchants have taken unfair advantage of consumers by greatly increasing prices for essential consumer goods and services. While pricing of goods and services is generally best left to the marketplace under ordinary conditions, In a declared state of emergency under abnormal disruptions, the public requires excessive increases be prohibited, right? So that's 396A. 396B, mirrors what the governor said in his executive order, right? There's that 10% that we were talking about. And as you can see, broad consumer protection statute, and it applies to a whole host of industries. Suffice it to say, in California, there's a very good chance it applies to you, your industry, and your business. And hopefully that's one of the reasons why you're with us on the call today. So it applies broadly, you can see that, and we also talked a little bit already about the 3 exceptions, which again is your rising costs, returning items to normal price after sale, and then 3, obviously, government sale or government consent and acquiescence. So typically the statute, right, 396, it runs for 30 days after a declared emergency, but it can be extended. And as I mentioned earlier, Governor Newsom has already extended per his executive order that our price gouging prohibition, right, our declared state of emergency issue is going to run at least through September 4th, 2020. Local governments and ordinances can also chime in as well on extending the prohibitions of and duration of the penal code statute. As I mentioned before, violators of the price gouging statute are subject to criminal prosecution. Under the penal code statute, 1 year imprisonment, a fine up to $10,000. There are also civil enforcement actions, civil penalties, et cetera, right? The Attorney General and DAs can enforce. And by the way, if there are persons or entities that have been the victim of price gouging, or have information regarding potential price gouging, whether that's a consumer or an employee or whoever, they can file a complaint at the website below, right? The Office of Attorney General for California. Challenges and risks, right? So price gouging can have a profound impact across commercial business and supply chains. Really, there is no limit to the affected and potentially affected industries. Consumer goods, healthcare, insurance, hospitality, transportation, government contracts, it's a long list. And ultimately, right, consistent with the theme of our presentation today, there are tremendous challenges, tremendous litigation risks, particularly for class actions, large exposures for all commercial businesses and employers. And as we all start to reopen, which is great, but there is likely to be a spike, and we already are seeing a spike, and we'll go through a couple of specific examples momentarily. Price gouging statutory violations are often brought in conjunction with other consumer statutory violations. California Unfair Competition Law, Consumer Legal Remedies Act. You also see them often, though, in conjunction with state and federal anti-competitive practices. Often claims of collusion or price fixing among market competitors. You may see price gouging claims in there. A related issue, right, and I know we're focusing largely on price gouging and raising prices, is the idea of price cutting. You may see a competitor in the marketplace, right, a large business that has cash on hand, or easy access to credit, whereas small businesses, right, they're barely skating through this pandemic, and they're trying to stay alive. There is an opportunity, right, for predatory price cutting to drive consumers out of the marketplace. And California does have, an unfair practices statute. It's Business and Professions Code 17043, and we're talking mostly about price gouging, but there is also a unique opportunity for price cutting and invocation of the anti-price cutting statute. False claims actions, another one, intellectual property, right? Like if you have a good or service and someone else is ripping off and selling, fake your products at predatory prices, you can easily get sucked into that lawsuit because folks think it's you. So, there's at least one, provider of personal protective equipment that is now spending a lot of time and energy and money, protecting its trademarks, and other intellectual property. So my last couple of minutes is going to give you a couple of real quick examples. And these are real class actions that have been filed in the last 30 days in California, all in the Federal District Court for the Northern District of California. So example one is a consumer class action alleging price gouging by a major online retailer on their website for various products. Anybody who bought a protected product on the website, and you can see the same standards, right? We're looking at the date, February 4th, 2020, at a 10% price increase. What's unique about this one is this particular online platform or website has third-party resellers, And so the theory of liability, right, says that not only is it you, it's you have to track and investigate and monitor and be responsible for everybody else who's on your site, and that's a pretty broad liability. The second class action is similar but different. It's a different retailer. Allegedly sold face masks at a 300% markup, N95 masks. And what's unique about this complaint is the allegation that this particular retailer gets a fee on every item, whether it sells it itself or whether it's a third party or an auction or whatever on its site. But since it gets a fee tied to the ultimate sales price, it doesn't have any incentives to stop price gouging. The third exemplar, consumer class. This is the egg class action. Big class action against 24 grocery stores, wholesalers for tripling the price of eggs during the pandemic. And literally everyone is covered by this because the proposed class includes almost everyone who's bought eggs in California from any one of these retailers, which covers a lot of people. Last slide here, how do you defend these? Obviously you can attack the appropriateness of class treatment and certification. You can challenge the main cause of action. But, the main thing, right, is again, look at the statute. Are you within the statute? Are you covered by the statute? Is it a necessary essential product? Is it within the time, place, and manner, where the statute applies? And then there are the exceptions we talked about: cost, pricing, and emergency supplies. So I hope this gives you something to think about, but price gouging is a big issue. So I'm going to turn it over to my colleague, Josh Salinas, to talk about privacy actions.
Thanks, John. This is Robert. We're obviously mindful of the time. Let us give you the CLE code. It's going to be SS2251. So if you want to get CLE credit for today's presentation, SS2251. And we will be running 10 minutes long for today's final segment of the program on COVID privacy issues as well as automatic renewal issues with respect to COVID. Go ahead, Josh.
Thanks, Robert. And so we want to be considerate of everybody's time. As Robert mentioned, we may be running over shortly, but if you have any questions about these topics, feel free to enter them in the chat. If we aren't able to get to them by the end of today, we'll follow up and reach out to you. So first, privacy is probably one of the big things that has been coming up with the ongoing pandemic. Even before the pandemic, you had businesses, not only in California, but around the world, bracing for the financial and operational impact of the new California Consumers Privacy Act, which just took effect earlier this year. But I know each of these privacy statutes we're going to talk about could have their own presentation, but the two main common ones we're going to be talking about are the SIPA, California Invasion of Privacy Act, and the CCPA. So first, turning to the SIPA, this is a statute that actually was enacted about 50 years ago, and so a lot of the litigation that's come up has been looking at the issues that have been involved with applying the statute to some of the new emerging technologies. It was originally intended to protect against the unlawful recording and monitoring of phone calls, but we've seen some challenges come up with it applying to voice over IP, mobile device-related communications, and then kind of software and mobile device apps. So the key things to know about this statute is that there's two key sections. One is Section 632, and the other one is 632.7. The first one, it applies to call recording or call monitoring over landlines. And that's 632, Section 632. And it applies to any person who intentionally and without the consent of all parties to a confidential communication by means of any electronic, amplifying, or recording device eavesdrops upon or records the confidential communication. And then with regards to 632.7, it applies to anybody who, without the consent of all parties to a communication, intercepts or receives and intentionally records or assists in the interception or reception of an intentional recordation of a communication transmitted between two cellular radio telephones, cellular radio telephone, and a landline telephone. And so just to kind of briefly look at the similarities and differences, both subsections involve the lack of consent. With 632, the key distinction is it's involving landline communications, but is limited to confidential communications. And then with 632.7, it involves cellular telephone, but is broader and is not limited to confidential communications. Now, why is this important? One, this has been pretty significant in that it has a significant statutory penalty. Each call violation is a $5,000 potential fine or penalty. And so when you look at the number of calls that a company may be receiving or making, and if they don't apply with the statute, just multiplying the number of calls times 5,000, you can see how the potential exposure can go up. This is significant with respect to COVID is because we're seeing with the pandemic, with the related stay-at-home orders, just consumers are no longer engaging with companies as much in brick and mortar stores, and so a lot of customer service interactions, whether it's calls or returns, are being made either electronically or over the phone. And many companies who want to record or monitor those calls for either customer service purposes or for training, needs to be aware of these restrictions. And so the things to be mindful of, are these communications confidential? Is the recording intentional, and what type of communications they are? This is significant with California just because of the nature of business in California with you having so many consumers. It's already an attractive forum for class actions. But the kind of key takeaways from this are you want to make sure that the warnings disclaiming that the call may be recorded or monitored is non-bypassable. We've seen plaintiffs become very creative and very clever recently in order to assert claims under this statute by making customer service calls and intentionally hitting zero or trying to bypass these in order to make a lawsuit. Another way we've seen is plaintiffs trying to call a reception or one department outside of customer service and then trying to get redirected and hoping they can bypass these automatic disclaimers. The other key consideration with this is, companies may want to have a standard script where the employees can read that off to provide this consent disclosure regarding the recording, but it's often best recommended to have a automatic recorded procedure just because you avoid the kind of human aspect where the person may not read it. And this is, has a rigid statutory scheme with the statute. There's little room for good faith defenses. And if the calls were recorded without consent, the company sometimes faces an uphill defensive battle. We've just already seen an extremely attractive plaintiffs bar with the attractivity of the forum in California, but also the heightened statutory penalties. So another big thing that we previously mentioned is with the CCPA. As I mentioned, it was already something that people were closely monitoring as it took effect earlier this year. And there's already been a number of lawsuits. It's already seen a wave of privacy lawsuits involved. Probably one of the most notorious ones has been the lawsuits that have been brought against Zoom, the remote conference sharing communication service, being brought after there were allegations about a month or two ago that information was being shared with Facebook. And so we saw that even though Zoom had updated their software, about 10 days later, a lawsuit, class action was already brought regarding privacy concerns. Now, with respect to the CCPA, the real purpose was to provide California residents with the right to know what data is being collected about them, to know, how that personal data is being used, who it's being disclosed to, the right to say no to the sale of that personal data, having access to that data, and then having equal service and prices even if they exercise any privacy rights. There's a brief description of what personal data is on the slide. One thing that is important to note is it does not include publicly available information. And so one of the key takeaways we wanted to focus on with the CCPA is the main private cause of action is really for security breaches. And so that's when there's an unauthorized access and disclosure of data. The two central questions at the heart of this kind of broad catch-all for security breaches is one, whether there was in fact a security breach, and then two, whether there was reasonable security in place prior to the breach. Separately, the CCPA allows for the state attorney general to enforce all of the requirements under the statute, such as the notice requirements, the right to be forgotten, the requirement to provide data upon request. But we've seen that the law applies to companies who do business in California through the scope of that definition, which inherently leads to the conclusion of companies around the world, whether they know it or not, just because with California being the world's fifth largest economy and the CCPA scope applying to California residents, I've seen just kind of the broad impact that the statute has. Taking a look at the practical effects of the CCPA, we see a likelihood that the transition from social distancing may lead to an increase in the need to screen and collect physiological data from consumers, especially as companies reopen their physical brick and mortar stores, and then also the potential with collecting data from employees who may be entering any physical spaces. Some of this data can include body temperature, maybe prior testing results regarding antibody testing, personal movement tracking based on cell phone information. We understand that there are some retailers already in Los Angeles County who are already screening some consumers for things such as temperature data. And so taking this kind of real world example, kind of looking forward is how it's going to be implemented, whether the retailers decide to implement some of these screening and data collection, or even if they're being compelled by government agencies. What are the privacy concerns, especially under the CCPA, with collecting and using this data? Under these scenarios, I think the thing to be well aware of is to have an established process for providing notice to each consumer, dealing with and providing verifiable customer requests, and then creating a response protocol to account for who the information is sent to and for what purpose. And even if the companies keep all the aforementioned factors in mind, there's still some numerous tricky questions to navigate, particularly given the fact that the CCPA does not limit companies to online notification, unlike some previous laws. With respect to employers, notice is going to be important as well. If you're going to be collecting data with employees, whether it's direct personal data, demographic data, or even kind of the referential data, it's important to provide notice of what data is being collected, how it may be used, and if there's any contact information for people who can reach out if they have any questions or comments about the notice disclosures. And so we're going to briefly touch on auto renewal and deceptive pricing actions. We previously mentioned some of the cases regarding membership and subscription-based services, and how there's been issues with refunds or charges, especially when some of those services may be closed. California has a specific auto renewal statute that governs any paid subscription or purchasing agreement that is automatically renewed until the consumer cancels. The real purpose is to provide consumers with information about those subscription terms, how they're going to be charged, and making sure they're providing affirmative consent when they're going to be charged on a recurring basis. We've seen more and more cases being brought in these cases with streaming services, theme parks, the delivery and kind of the delivery box services, just because it's such an attractive business model. You have this, set it and forget it, where consumers are signing up, especially with the convenience and sometimes cost savings, and then you have this kind of recurring steady revenue stream coming in. The key thing with this statute is to know that you have some specific categories of disclosures that need to be made. One is to make sure that you have the key terms of the offer and the subscription terms disclosed in the manner that calls attention to the auto renewal language, and you want to make sure that it's in visual proximity to the request for consent. Sometimes issues come up where the disclosure of the terms are on one page, and then the actual consent is not till a few clicks or later pages down the line. And so sometimes there's a dispute and fight between the design department and then the legal department, but you want to make sure that there are some clear requirements of the statute to make sure that you have those terms in close proximity to the affirmative consent button. So other types of things that need to be disclosed: the nature of the subscription or purchasing agreement, how to cancel the offer, making sure you have a cost-effective, timely, and easy-to-use mechanism for cancellation, and then providing information on how to cancel. One thing to note with the remedies under the statute is that it essentially provides the employee or the customers with a gift, an unconditional gift. So not only are they entitled to refunds, but they're entitled to keep the services or goods that they've already acquired. Some of the defenses and strategies are similar to what we've seen with other class actions. So having an enforceable mandatory arbitration provision and class action waiver will be helpful. We've seen some district courts already dismissed these disputes at the pleading stages based on those enforceable arbitration or class action waivers. And then there was also a good faith exception under the statute. And there's also certain exceptions for certain businesses that apply. And then the last thing we want to touch on is just some of the issues with false advertising with respect to deceptive pricing. We've covered some of the issues with predatory pricing, with having prices that is too high, but then also maybe some predatory pricing that's too low. One of the issues that we're seeing come up is a wave of class actions with respect to false advertising or pricing that doesn't seem to be reasonably related to what's being advertised to the actual true price or cost of the item. For example, there was a case where a consumer purchased a home electric product. There was a part that was $1.99, but the shipping ended up being $8. And so they brought a lawsuit saying, how could that be reasonably related? Courts have given some deference to businesses saying that, if there's really, if there's no deceptive, misleading information, then, the companies are free to, set their own prices. The consumers are free to shop wherever they want. And in this instance where you have the $2 item, but the $8 shopping or the $8 shipping, the court did note that, the consumer is free to shop wherever they want, but they didn't see anything, deceptive specifically about that. On the other hand, we've seen cases where the courts found that in one instance, you had a retailer having multiple sites selling the same product, but having different types of shipping, even though it was claimed to be the most economical price. And the court found that in that instance where the retailer did have multiple websites, but charging different shipping for the same item, that there could be a sufficient claim for deceptive pricing. So the key takeaway with these, some of these privacy and consumer issues that we've discussed kind of looks at disclosures, making sure you have sufficient, reasonable disclosures, having consent where it's applicable, and then ensuring you have some good defensive terms in place, whether it's mandatory arbitration or consumer class action waivers.
Thanks, Josh, and thanks to the audience for patience today. Like we said, each of these topics could be a webinar in themselves. We've actually covered a lot of this material on our consumer class action blog. So if you want more on one of these specific topics, I would direct you to our blog, which is www.consumerclassdefense.com, and also direct you to our COVID-19 Resource Center. There's a lot of good materials on that as well. With respect to any specific questions that you have, feel free to reach out to the panel members. We're happy to get back to you. And again, thank you for your time. With that, I'll turn it over to our producer to conclude.
Thank you. This concludes today's webinar, and thank you for attending.